The first thing I noticed wasn't the line of black SUVs, it was the silence. For 3 years, every morning at sunrise, dozens of luxury pickups, landscaping trailers, delivery trucks and contractor vans rolled through the narrow gravel access road that cut across the edge of my ranch. The engines usually echoed through the valley before the cattle even wandered toward the creek. That morning, nothing. Not a single tire moved. I stood on the ridge overlooking the entrance, coffee still warm in my hand, watching nearly 200 furious homeowners trapped behind the heavy steel ranch gate I had legally closed less than an hour earlier. Someone leaned on a horn, then another. Within seconds, it sounded like an orchestra of anger. People climbed out of their vehicles, waving their arms. A woman in a business suit slammed her car door so hard it echoed across the pasture. One man kicked the locked gate. Another pulled on the chain with both hands. None of it mattered. The lock wasn't temporary. The gate wasn't symbolic. It was sitting on my property, exactly where the official state survey said it belonged. I watched calmly as a white-haired man wearing an expensive golf shirt stormed toward the fence. He jabbed a finger through the bars. "You can't do this." I took another sip of coffee. "I already did. You've blocked an entire community." "No," I answered quietly. I closed my private road. His face turned bright red. "That's impossible." "Then you probably should have checked the property records before your HOA started charging me $5,000 a day." The crowd suddenly became quieter. Some homeowners turned toward him instead of me. They clearly hadn't heard that part before. "What $5,000? Someone asked. The man ignored them. "You've committed criminal obstruction." I reached into my jacket pocket and held up a folded document. "This is the state's recorded easement cancellation." Then I held up another. "And this is the county survey confirming the road belongs entirely to my ranch." His confidence cracked for the first time. He looked behind him toward several members of the HOA board, who suddenly refused to make eye contact. A deputy sheriff's cruiser rolled slowly toward the entrance, then another. Several homeowners actually smiled, convinced the deputies had arrived to arrest me. The lead deputy stepped out, adjusted his hat, and walked directly to my side of the gate. "Morning, Mr. Carter." "Morning, deputy." He glanced at my paperwork before nodding once. "Everything still secured?" "It is." He turned toward the furious crowd. "I'm going to ask everyone to step away from the gate." Instant chaos erupted. "You've got to be kidding. He's holding us hostage. Arrest him." The deputy raised one hand. "Folks, this appears to be private property." The shouting doubled. One woman screamed that she'd sue everyone wearing a badge. Someone demanded the governor's phone number. The HOA president pushed through the crowd until he stood inches from the deputy. "You work for the county. Make him open this gate." The deputy's expression never changed. "I enforce the law. Then enforce it. I intend to." Before anyone could speak again, another vehicle appeared. A dark blue SUV with the unmistakable seal of the State Department of Transportation pulled slowly onto the shoulder. Behind it came 2 more state vehicles, then a truck carrying professional survey equipment. I felt my heartbeat finally slow, because unlike everyone else standing there, I knew exactly why they had come. And the HOA president realized it 1 second later. "My name is Ethan Carter. I'm 46 years old, and I make my living the same way my father did, and his father before him, raising cattle on a ranch just outside Bozeman, Montana." People often imagine ranch life as endless sunsets and peaceful rides across open fields. There are moments like that, sure, but the reality is a lot less glamorous. My alarm goes off before dawn almost every day. Fences break, water lines freeze, calves arrive in the middle of snowstorms. Equipment chooses the worst possible time to fail. It's hard work, but it's honest work, and every acre of that land means something to me. When I was a kid, my grandfather used to point across the valley and tell me stories about how our family first settled there after returning from World War II. He never spoke about money. He spoke about responsibility. "Son," he'd say while leaning on an old cedar fence post, "you don't really own land. You borrow it from your grandchildren." That sentence stayed with me. When my parents passed away within 3 years of each other, I inherited the ranch, not because I was the oldest, but because I was the only one who wanted the responsibility. My younger sister built a life in Seattle and never looked back. She told me, "You belong out there more than I ever did." She was right. I invested every spare dollar back into the ranch. New fencing, better irrigation, healthier breeding stock, modern equipment. It wasn't about getting rich. It was about leaving the place better than I found it. For years, life followed a comfortable rhythm. My nearest neighbors were other ranchers who believed a handshake still meant something. We'd help each other mend fences after storms, pull tractors out of mud, or gather escaped cattle without keeping score. If someone needed help, you showed up. That changed the year Redstone Ridge Estates broke ground. The development was marketed as luxury mountain living, complete with custom homes, private parks, stocked fishing ponds, and breathtaking views of the Gallatin Valley. Billboards promised buyers the perfect blend of nature and modern elegance. To me, it looked like hundreds of expensive houses dropped into cattle country. Still, I wasn't against growth. People have a right to build, just like I have a right to ranch. The developers even introduced themselves before construction began. A sharply dressed project manager named Daniel Pierce pulled into my driveway one afternoon, wearing polished boots that had clearly never touched real mud. He stepped out with a practiced smile. "Mr. Carter, Daniel Pierce. Just wanted to introduce ourselves. We hope to be good neighbors." "I appreciate that," I replied, shaking his hand. He glanced around my property. "You've got beautiful land." "Thank you. We'll probably have some construction traffic for a while. Nothing too disruptive, as long as everyone stays where they're supposed to." He smiled again. Of course. For nearly a year, everything seemed exactly as promised. The crews waved when they drove past. I waved back. No problems. Then one afternoon, I noticed survey flags planted along the edge of my pasture. Bright orange, perfectly straight. I frowned. I hadn't ordered a survey. Walking over, I saw fresh tire tracks crossing through a section of grass where nobody had permission to drive. At first I assumed it was an honest mistake. Survey crews occasionally wandered onto neighboring properties before correcting their work. I pulled out the flags and stacked them neatly beside the fence. The next morning, they were back. This time there were twice as many. I drove to the construction entrance and found several workers unloading equipment. "Morning," I called. One of them looked up. "Morning. Who put survey markers on my ranch?" The man hesitated before pointing toward a white pickup. "You'll have to ask the engineer." A younger surveyor walked over carrying a clipboard. "Can I help you?" "I think your crew crossed onto my property." He checked his papers. "Our plans show this strip belongs to the development." I laughed softly. "They're wrong." He looked uncomfortable. "I don't make the maps, sir. I understand." "Then whoever does should come talk to me." He nodded politely, promised to mention it, and we parted without raising our voices. I expected the issue to disappear. Instead, it grew. Within 2 weeks, construction trucks had begun using the gravel road that crossed the eastern edge of my ranch more frequently. It wasn't a public road. It had always been a private ranch access road, built decades earlier by my grandfather. We'd occasionally allowed utility crews or neighboring ranchers to use it as a courtesy, but permission was always requested first. Now nobody asked. Every day, more trucks rolled through. Every day, the dust settled over my hayfields. And every day, I had the unsettling feeling that someone had quietly decided my property no longer belonged entirely to me. One evening, as I closed the ranch gate, I noticed something that made the hairs on the back of my neck stand up. A brand new sign had been bolted beside my own fence. It read, "Property of Redstone Ridge Homeowners Association. Authorized access only." I stared at it for several long seconds. Then I looked beyond it, toward the lights of the growing subdivision. Something was terribly wrong. I stood there for nearly a minute, staring at the sign bolted to my fence. "Presoff of Redstone Ridge Homeowners Association. Authorized access only." The words didn't just irritate me, they made my stomach tighten. Someone hadn't simply made a mistake. Someone had claimed my land. I unbolted the sign, laid it carefully in the bed of my truck, and drove straight to the sales office at Redstone Ridge Estates. The place looked more like a luxury resort than a construction site. Stone columns framed the entrance, expensive SUVs filled the parking lot, and a massive model of the finished neighborhood sat in the lobby under bright lights. A receptionist smiled politely. "Good afternoon. How can I help you?" "I'm looking for Daniel Pierce." She glanced toward a hallway. One moment. A minute later, Daniel appeared, still wearing the same polished smile I'd met a year earlier. "Ethan, good to see you." I set the sign on his conference table with a loud metallic thud. His smile disappeared. You want to explain why this was attached to my fence? He looked down at it, then back at me. I'm sure there's been some confusion. No, I replied evenly. Confusion ends when someone drills holes into another man's fence. He folded his hands. Our engineering department updated the site plans. My deed hasn't changed. Our understanding is that the access corridor belongs to the development. My understanding comes from the county recorder's office. For a few seconds, neither of us spoke. Then Daniel leaned back in his chair. Mr. Carter, these projects involve complicated property adjustments. There haven't been any adjustments. I think you're overreacting. I almost laughed. So if I walked into your office tomorrow, hung a sign saying this building belonged to me, you'd call that an overreaction? His jaw tightened. I'm trying to solve this professionally. So am I. I slid a folder across the table. Inside were copies of my deed, the original subdivision survey from the 1950s, and tax maps showing the gravel road entirely within my property boundary. He barely glanced at them. Our legal department will review those. They should have reviewed them before installing signs on my ranch. Without another word, I picked up the sign and walked out. For about a week, nothing happened. Then the letters started arriving. The first one looked official enough that I assumed it was from the county. Instead, it carried the Redstone Ridge HOA logo. I opened it at my kitchen table. The letter stated that my unauthorized interference with HOA infrastructure had violated community regulations. I read the sentence twice, then 3 times. Community regulations? I didn't even live in their subdivision. The notice demanded that I restore HOA property within 72 hours. Failure to comply would result in daily fines. I actually chuckled. They'd mailed HOA rules to someone who wasn't a member of the HOA. I tossed the letter aside. 3 days later, another envelope arrived. This one wasn't funny. It informed me that I had been assessed a $5,000 fine, not total, per day, beginning immediately. I drove straight to the HOA office. This time, Daniel wasn't waiting. Instead, I was escorted into a boardroom where 6 people sat behind polished oak tables as if they were holding court. At the center sat Richard Harrison, the HOA president. He looked to be in his early 60s with silver hair, an expensive navy blazer, and the kind of expression that suggested he enjoyed telling people what they couldn't do. He didn't stand when I entered. Mr. Carter. I remained standing. You sent me a bill. We sent you notice of repeated violations. I'm not part of your HOA. You interfere with HOA property. No, I answered. You're interfering with mine. A woman to Harrison's left pushed several glossy maps across the table. Our master development plan clearly identifies the eastern access road as community infrastructure. I looked at the maps. They're pretty. Harrison frowned. They're official. They're marketing brochures. One board member scoffed. Harrison leaned forward. You need to understand something. I'm listening. Redstone Ridge represents nearly 400 families. And? You represent one ranch. The room fell silent. I understood exactly what he was implying. Strength in numbers, money, political influence, pressure. He smiled slightly. This development contributes millions in tax revenue. My property taxes aren't exactly pocket change either. You can continue resisting. He slid another document toward me. Or you can sign an access agreement and avoid further penalties. I didn't touch the paper. What does it say? It grants the HOA permanent use of the roadway. For free? He smiled again. It benefits everyone, except me. It increases regional property values. My ranch isn't for sale. It doesn't have to be. That sentence lingered in the room. I looked him directly in the eyes. Was that supposed to sound like a threat? It was a practical observation. I gathered every document they'd placed in front of me. You'll hear from my attorney, Harrison laughed. By the time lawyers finish arguing, your fines will exceed $500,000. I walked toward the door. Behind me, he called out calmly, We'll also notify your lenders. That stopped me cold. I turned slowly. What lenders? If your financial position changes, creditors deserve to know. I hadn't borrowed against the ranch in years. He knew that. Which meant he wasn't warning me. He was trying to make me panic. I left without another word. But the intimidation didn't stop there. Within days, contractors refused deliveries after anonymous complaints claimed my access road was under legal dispute. Utility inspectors appeared without notice. County offices began receiving calls questioning my property boundaries. Even neighbors started asking if I'd secretly sold part of the ranch. Someone was orchestrating all of it. This wasn't an HOA collecting fines anymore. It was a coordinated campaign to break me. And for the first time since my grandfather left me this land, I realized I wasn't fighting a petty neighborhood board. I was fighting people who believed they were powerful enough to rewrite ownership itself. For the first time in my life, I couldn't solve a problem with a fence post, a wrench, or 16 hours of hard work. This was paperwork, influence, law. And if I made one careless move, the people behind Redstone Ridge would bury me under enough legal fees to make the truth irrelevant. That realization led me to the one person in Gallatin County who had a reputation for refusing to be intimidated. Margaret Maggie Donovan. She was 62, a former assistant state attorney who had spent nearly 35 years handling land disputes, easement litigation, and property fraud cases before opening a small private practice. There appeared January Worlds. It occupied the second floor of a century-old brick building overlooking Main Street in Bozeman. The carpet had probably been installed sometime during the Reagan administration, and the coffee tasted like burnt dirt. But every inch of the room said the same thing. Someone here cared more about winning than decorating. Maggie barely looked up as I walked in, carrying 2 banker boxes filled with documents. "You Ethan Carter?" "I am." She pointed toward the boxes. "Good. Means you didn't come expecting miracles." I laughed. "I was hoping for one." "You won't get one." She stood, extended a firm hand, and motioned toward a conference table. "What you might get is evidence." For nearly 3 hours, I told her everything. The survey stakes, the HOA letters, the fines, the sign bolted to my fence, the threats. Daniel Pierce, Richard Harrison. She interrupted only to ask precise questions. "When did construction traffic first begin using your road? Who gave them permission? Have you ever signed an easement? Any verbal agreements? Any county maintenance?" When I answered no to the last 3, she simply nodded and kept writing. Finally, she leaned back. "I've got good news." I waited. "If everything you've told me is accurate, they have a problem." "What kind of problem?" "They're acting like ownership and access are the same thing." "I don't follow." She pulled a legal pad toward us and sketched 2 rectangles. "This is your ranch." She drew a thin line through one edge. "This is your private road." Then she drew another box representing Redstone Ridge. "They may have relied on your road for convenience." She tapped the paper. "Convenience isn't ownership. So why are they acting like it is?" She looked at me over her reading glasses. "That's exactly what we're going to find out." The next week became a full-time investigation. Maggie filed requests with the county recorder, the planning department, and the Montana Department of Transportation. Meanwhile, I spent my days digging through decades of family records stored in my grandfather's old machine shed. Dust covered everything. Metal filing cabinets, rolled survey maps, coffee-stained notebooks, receipts dating back to the 1970s. One afternoon, while sorting through a stack of yellowed folders, I found a leather binder labeled simply East Boundary. Inside were survey maps older than I was. Every corner, monument, every bearing, every property marker. Everything matched my deed exactly. There was no mysterious HOA road, no public dedication, no transfer, nothing. I photographed every page and drove them straight to Maggie's office. She spread the originals beside the county records she'd received that morning. "They're identical," I said. "They should be." "So we're done?" She didn't answer. Instead, she reached for another file that had just arrived from the planning department. "This," she said quietly, "is where things get interesting." It was Redstone Ridge's original development application. Hundreds of pages, engineering reports, drainage studies, environmental reviews, traffic analyses. At first glance, everything looked routine. Then Maggie stopped turning pages. Her finger rested on a site access map. "Look here." I leaned closer. The subdivision had originally been designed with 2 permanent entrances connecting to public highways. One entered from the south. The second connected to a county-maintained road on the east. Neither crossed my ranch. "So why are they using my road?" I asked. Maggie flipped another page. An amendment dated 18 months later. The eastern entrance had been removed. Stamped across the page was one word: denied. She found another document, then another. Within minutes, we had a timeline. The state had refused to approve the second entrance because of environmental concerns, involving a protected wetland. Without that road, the entire subdivision depended on the gravel road crossing my property. I stared at the documents. I knew. Oh, Maggie replied quietly. They absolutely knew, but they still sold hundreds of homes. She nodded, promising permanent legal access. Neither of us spoke for several seconds. Then she reached for one final envelope that had arrived through a public records request. This came from county email archives. She unfolded several printed emails, exchanged between the developer, engineering consultants, and HOA organizers, months before the first home had even been sold. Most were routine. Scheduling meetings, construction updates, permit discussions. Then one message caught my eye. It was from Daniel Pierce. The subject line read, "Temporary Access Strategy." My stomach tightened. Maggie read the highlighted sentence aloud. "We'll continue using Carter's Ranch Road until ownership issues can be resolved after occupancy." I looked up. What does resolved mean? Maggie slowly slid another email across the table. This one was from Richard Harrison, written before he was ever elected HOA president. It contained a single sentence that made my blood run cold. "Once enough residents move in, public pressure will force Carter to surrender the road." The room went completely silent. This wasn't a misunderstanding. It wasn't sloppy paperwork. It wasn't even aggressive negotiation. It was a plan, and they'd put it in writing. I stared at Harrison's email for what felt like an eternity. The words refused to change. "Once enough residents move in, public pressure will force Carter to surrender the road." There it was. Not an opinion. Not a misunderstanding. A strategy. Someone had decided years earlier that my family's property was an obstacle to be removed, not through negotiation, but by making my life so miserable that giving up seemed easier than fighting back. I looked at Maggie. "So they built an entire neighborhood assuming I'd eventually cave?" She folded her hands. "That's exactly what it looks like. And they sold homes based on that assumption?" She nodded. "If these emails are authentic, and I have every reason to believe they are, they're devastating." I let out a slow breath. My grandfather always said the truth leaves footprints. Maggie smiled faintly. "And sometimes people leave those footprints in email." Over the next several days, Maggie's office became mission control. Every document was scanned, indexed, and placed into color-coded binders. Original deeds, county plats, survey records, planning commission minutes, environmental permit denials, internal emails, photographs of the road dating back almost 50 years, even aerial images from different decades confirmed the same thing. The gravel road had always belonged to the Carter Ranch. Nothing in the public record transferred ownership. Nothing granted the HOA a permanent easement. Nothing supported the fines they were sending me every morning. Still, Maggie wasn't satisfied. "Winning isn't enough," she said one afternoon. "We have to make it impossible for them to confuse the judge." She hired Thomas Briggs, a licensed land surveyor with nearly 40 years of experience and a reputation that both developers and attorneys respected. Thomas spent 2 full days walking my property with GPS equipment, accurate to within fractions of an inch. He located the original iron boundary pins driven into the ground decades earlier. Most were still exactly where the 1952 survey said they would be. When he finished, he handed me a copy of his preliminary report. His conclusion was only one sentence long. The disputed roadway lies entirely within Parcel 17A, owned exclusively by Ethan Carter. I read it twice. For the first time in weeks, I felt hope. Then my phone rang. It was my foreman, Jake Morales. His voice was tense. "Ethan, you need to get back here." "What happened?" "The HOA's here." By the time I reached the ranch, 6 luxury SUVs were parked near the eastern gate. Richard Harrison stood beside them with several board members and 2 private security guards wearing matching uniforms. A crowd of curious homeowners had gathered behind them. As I climbed out of my truck, Harrison smiled as though we were old friends. "Mr. Carter, what are you doing on my property?" "We're conducting an inspection." "No, you're trespassing." One of the security guards stepped forward. "This roadway services our community. It services whoever I allow." Harrison held up another thick envelope. "You now owe $485,000 in accumulated HOA penalties." I didn't even reach for it. "I'm not accepting that." It doesn't matter. He placed the envelope on the hood of my truck. The debt exists whether you acknowledge it or not. Several homeowners watched nervously. An older couple whispered to each other. A younger man finally spoke up. Richard, is this really his land? Harrison didn't answer him. Instead, he looked directly at me. You've had every opportunity to cooperate. I've had every opportunity to surrender. Same thing. No, I replied. Not even close. His smile disappeared. You understand what happens if this continues? I think you should tell me. We'll record liens. You can't. We'll petition for forced access. You can try. We'll seek emergency court orders. I'll be there. He took one slow step closer. And while all that's happening, every homeowner in this subdivision will know you're the reason they can't expand emergency access. I understood exactly what he was doing. He wasn't talking to me anymore. He was talking to the crowd behind him, turning me into the villain. A woman folded her arms. So because of him, we're stuck with one entrance. Before I could answer, Harrison nodded dramatically. Unfortunately, I spoke loudly enough for everyone to hear. Ask him why the state denied the second entrance. The crowd grew quiet. Harrison's jaw tightened. I continued. Ask him why he promised permanent access over land he never owned. Several people exchanged confused looks. One homeowner frowned. What second entrance? Harrison interrupted immediately. This isn't the place. No, I said. This is exactly the place. He pointed at me. You're spreading misinformation. I reached into my truck and pulled out a copy of the state planning documents. These came from the county. His expression changed instantly, just for a second, but I caught it. So did Maggie, who had quietly pulled into the driveway moments earlier. She walked toward us carrying another folder. Richard Harrison, he turned. I'm Margaret Donovan, counsel for Mr. Carter. She handed him a sealed envelope. You've officially been served. He glanced at the caption on the first page. His confident smile faded. The lawsuit wasn't just asking the court to dismiss the HOA's fake fines. It alleged fraud, slander of title, trespass, abuse of process, and civil conspiracy against the developer, the HOA, and several named individuals, including Harrison himself. For the first time since this nightmare began, I saw genuine fear in his eyes, but instead of backing down, he did something none of us expected. He laughed. Then he looked straight at me and said, "You'd better enjoy your road while you still have it." That night, just after midnight, my security cameras captured headlights approaching the eastern gate. Someone had come to my ranch, and they weren't there to talk. The notification from my security system jolted me awake at 12:17 a.m. I reached for my phone on the nightstand. Motion detected. East Gate. I opened the live camera feed. 2 pickup trucks without company logos had stopped just outside the entrance to my ranch. 4 men climbed out wearing hooded sweatshirts, despite the warm summer night. One of them carried a pair of bolt cutters. My pulse quickened. What the hell? Before I could grab my truck keys, another set of headlights appeared. This time, it was a Gallatin County Sheriff's cruiser. The deputy pulled in behind the pickups, his emergency lights flashing just once. The 4 men froze. Within minutes, they were being questioned, while another deputy photographed the damaged lock they had already managed to cut halfway through. By sunrise, Maggie already had copies of the incident report. She smiled for the first time in weeks. They've handed us another piece of evidence. Think Harrison sent them? She shook her head. I don't speculate. But whoever did this couldn't have picked a worse night. The sheriff's report documented attempted trespass, property damage, and statements from 2 homeowners who admitted they'd been told they were recovering HOA property. Those statements would matter later. A lot. 3 weeks later, Courtroom 3 of the Gallatin County Courthouse was standing room only. Word had spread far beyond Bozeman. Homeowners from Redstone Ridge filled nearly every bench. Local ranchers stood shoulder to shoulder along the back wall. Reporters quietly organized notebooks and cameras outside the courtroom doors. Nobody wanted to miss what had become the county's biggest property rights case in years. I adjusted my tie nervously. Maggie noticed. First time in court? As a plaintiff, she smiled. Good. Why's that good? It means you still respect the room. The courtroom doors opened. Bailiff, all rise. Everyone stood as Judge Harold Whitmore entered. He was a former Army JAG officer, known for running a disciplined courtroom and having very little patience for gamesmanship. After reviewing the filings, He looked over his glasses. This matter concerns disputed property rights, alleged fraudulent assessments, easement claims, and several related causes of action. He paused. I trust both sides are prepared. The attorneys answered simultaneously, Yes, Your Honor. The HOA's lead attorney, Victor Langley, delivered the opening statement. He was polished, confident, smooth. Ladies and gentlemen, he began, turning slightly toward the judge, this case is about community necessity. Hundreds of innocent homeowners have relied upon this roadway for years. Mr. Carter's sudden decision to restrict access endangered public safety and disrupted lawful expectations. He spoke for nearly 20 minutes. He described me as unreasonable, uncooperative, hostile toward development, a man unwilling to compromise. Not once did he mention the fake fines. Not once did he mention the emails. When he finally sat down, Maggie stood. She carried only a thin folder. No dramatic gestures, no raised voice. Your Honor, she began calmly, opposing counsel asks this court to ignore one simple fact. She held up my deed. My client owns the road. Silence. The defendants never purchased it. She held up the county survey. They never received an easement. Another document. They never obtained state approval for alternate access. Another. They nevertheless imposed $5,000 daily fines against a man who was never a member of their homeowners association. She looked directly at Harrison. They attempted to pressure him into surrendering property they knew they did not own. The room was completely still. The first witness was Thomas Briggs, the licensed surveyor. He explained every boundary marker with remarkable patience. Using enlarged maps displayed on courtroom monitors, he identified original iron pins placed in 1952. He described GPS verification, historical plats, modern coordinates. Then he delivered the sentence Maggie had been waiting for. There is zero measurable overlap between the HOA property and Mr. Carter's roadway. Victor Langley stood for cross-examination. Mr. Briggs, is surveying an exact science? Within accepted tolerances. So mistakes happen. They can. Could this be one? Thomas smiled politely. No. Why not? Because every survey conducted over 74 years reaches the same conclusion. A few people quietly chuckled. Judge Whitmore looked over the courtroom. Let's keep reactions to ourselves. Next came county planning officials. They authenticated permit files, environmental records, transportation approvals, the denied second entrance. Then Maggie introduced the Planning Commission minutes. Every page was certified, every signature verified. Victor objected twice. Both objections were overruled. The evidence stayed. Finally, Maggie approached the evidence cart, carrying a single manila folder. I recognized it immediately. The emails. She looked at Harrison. Mr. Harrison, before becoming HOA president, were you involved with the Development Planning Committee? His attorney objected. Foundation, overruled, Judge Whitmore replied. Harrison shifted in his chair. Yes, Maggie unfolded the first email. Do you recognize this correspondence? He glanced at it briefly. I believe so. Did you write the sentence stating, once enough residents move in, public pressure will force Carter to surrender the road? The courtroom became so quiet, I could hear someone set down a pen. Harrison swallowed. I don't recall the exact wording. Maggie handed him the document. Perhaps reading your own email will refresh your memory. He looked down. His face slowly lost color. Judge Whitmore leaned forward. Mr. Harrison? After several painfully long seconds, he answered in a voice barely above a whisper. Yes. The courtroom erupted in murmurs. The bailiff immediately called for order, but Maggie wasn't finished. She reached into the folder one last time. Your Honor, she held up another document none of us, except her, had seen before. I'd like to introduce Exhibit 47. Judge Whitmore adjusted his glasses. What is Exhibit 47? Maggie took a slow breath. A signed internal memorandum from the developer's executive board, acknowledging they knew, before selling the very first home, that they had no permanent legal access to the subdivision unless Mr. Carter voluntarily surrendered his private road. The judge's expression changed instantly. Across the courtroom, Victor Langley closed his eyes, and Richard Harrison slumped back into his chair, realizing the case had just taken a catastrophic turn. The judge reached for the document, but had not yet announced his ruling. Judge Whitmore accepted Exhibit 47 from the bailiff without saying a word. The courtroom was so quiet, I could hear the faint hum of the air conditioning. He spent several minutes reading the memorandum, occasionally comparing it with the emails already admitted into evidence. Every page he turned seemed to make the room feel heavier. Across the aisle, Victor Langley no longer wore the confident expression he'd brought into court that morning. He whispered urgently to Richard Harrison, who simply stared at the defense table, his hands clasped tightly together. Finally, the judge closed the folder. He looked directly at Langley. "Counsel." "Yes, Your Honor. Did your clients disclose this memorandum during discovery?" Langley hesitated. "I was not personally aware of its existence." "That was not my question." Another pause. "No, Your Honor." Judge Whitmore's voice hardened. "That's troubling. Very troubling." Maggie remained perfectly still beside me. She had warned me that experienced trial lawyers never celebrated before a ruling. I followed her lead. But inside, my heart was pounding. The judge looked toward Harrison. "Mr. Harrison, please stand." He rose slowly. "You testified that your association believed it possessed lawful authority over Mr. Carter's roadway." "Yes, Your Honor." Judge Whitmore lifted the memorandum. "This document states the exact opposite." Harrison swallowed. "It appears that way." "It doesn't appear that way." The judge tapped the paper. "It says that way." No one spoke. Judge Whitmore continued. "It further states that your organization intended to obtain the roadway through what it describes as economic pressure after occupancy." He looked over his glasses. "Is economic pressure your preferred phrase for assessing fabricated $5,000 daily fines against a man who was never subject to your governing documents?" Harrison opened his mouth. Nothing came out. "I asked you a question." "No, Your Honor." The answer barely reached the microphone. The judge nodded once. "I didn't think so." After a brief recess, everyone returned to the courtroom for the ruling. I had imagined this moment dozens of times over the previous months. In every version, I thought I'd feel relief. Instead, I felt exhausted. Judge Whitmore began reading from a written opinion that filled nearly 30 pages. He found that the Carter Ranch had held uninterrupted title to the roadway for more than 70 years. He found that no easement, express, implied, or prescriptive, had ever been granted to the developer or the HOA. He found that the HOA possessed no legal authority whatsoever to assess fines against me. Then his tone became even more direct. "The evidence establishes a deliberate pattern of intimidation designed to coerce the plaintiff into surrendering private property without lawful compensation." Several homeowners gasped. The court further finds that the defendants knowingly misrepresented the legal status of the roadway while marketing residential properties. I saw one couple in the gallery turn toward Harrison in disbelief. The judge wasn't finished. Accordingly, he adjusted his glasses. "All HOA assessments issued against Mr. Carter are hereby declared null and void." A weight I hadn't realized I was carrying disappeared from my shoulders. "The court permanently enjoins the defendants from entering or using the plaintiff's roadway without his express written permission." Maggie quietly squeezed my arm. Then came the part no one expected. "Based upon the evidence presented regarding discovery violations, fraudulent conduct, and abuse of legal process, this matter is referred to the Montana Attorney General and appropriate regulatory authorities for further investigation." Victor Langley slowly lowered his head. Richard Harrison simply stared ahead, motionless. The months that followed changed the valley. State investigators confirmed that the developer had knowingly relied on access rights they didn't own. Civil penalties followed. Several executives resigned before the investigations were complete. Richard Harrison stepped down as HOA president before the board formally voted to remove him. Homeowners who had trusted the developer filed their own lawsuits. Many later told me they had never known the truth. One afternoon, nearly 6 months after the trial, a young couple from Redstone Ridge knocked on my front door. I recognized them from the courtroom. The husband removed his cap. "Mr. Carter, we owe you an apology." "You don't owe me anything. We believed what they told us." His wife looked embarrassed. "They said you were trying to trap our neighborhood." I smiled sadly. "I never wanted a fight. We know that now." The husband extended his hand. "I'm sorry." I shook it. "Thank you." Word spread throughout the county that the Carter Ranch had won, not because one rancher defeated an HOA, but because the truth defeated intimidation. The state later approved a completely new public access project, one that didn't cross my property, and the subdivision finally received a legal entrance built at the developer's expense. As for my ranch, the steel gate still stands where my grandfather built it decades ago. Most mornings I lean against that same fence with a cup of coffee, watching the sun rise over the pastures. The road beyond it is quiet again, not because I wanted to keep people out, but because, in America, ownership still means something. And sometimes, all it takes to remind people of that is refusing to surrender what was never theirs. Nearly a year has passed since the courtroom doors closed behind us, and life on the Carter Ranch has finally settled back into the rhythm I almost lost. The cattle still need feeding before sunrise, fences still need mending after storms, and every evening I can stand on my porch knowing that the land beneath my boots remains exactly where my grandfather intended it to be, protected, respected, and still in our family's hands. Looking back, I realized this fight was never really about a gravel road. It was about something much bigger. When people with money and influence believe they can pressure ordinary people into giving up their rights, they count on fear and exhaustion to win. They never expect someone to quietly gather the facts, trust the law, and refuse to back down. If this experience taught me anything, it's this: never surrender what is rightfully yours, just because someone more powerful tells you that resistance is hopeless. Truth may take longer to prove than a lie, but when it's backed by evidence, patience, and courage, it has a way of catching up. Thank you so much for staying with me through this journey. I truly appreciate every minute you've spent listening to my story. Now I'd love to hear from you. Have you ever dealt with an HOA, a difficult neighbor, or someone who tried to claim something that legally belonged to you? Share your experience in the comments. I read as many as I can, and your story might help someone else facing a similar situation. If you enjoyed this story, don't forget to like, subscribe, and turn on the notification bell so you never miss another gripping property rights and HOA drama. Until next time, take care of the people you love, stand up for what's right, and remember, some battles aren't about winning land, they're about protecting your dignity. The end.